And there's another thing that we have in Pennsylvania, which again often does not get explained, which is the difference between what's considered full coverage and full tort. Has anybody ever heard those words before? Okay. A lot of times the advertisements from insurance companies say, we give you full coverage. We'll make sure you have full coverage. Full coverage simply means that you're complying with the government requirements are. That's all that full coverage means. And I can't tell you, and it breaks my heart every single time. They're like, but I asked, and they said it was full coverage, and they said it was full coverage. I'm like, they said full coverage. The difference is full tort. There's full tort, and then there's limited tort. And it's really a very important thing to understand. In limited tort, that is when you are signing away your own rights to bring a claim if you get injured, should a judge or standing case law make a decision that your injury is not serious. There are other exceptions too. For instance, if you're a pedestrian, and I'll go over those other exceptions. But you have, when you select limited tort, what you have done is you have waived rights. The rights that the government says that you can't waive without signing. But you have waived your own rights. And what does that actually mean? A lot of people I see a lot of people come into my office, and many people have had an accident, and maybe it didn't happen right away. It might have happened 9 months ago, a year ago, 18 months ago, and they truly, truly thought they were going to get better. They believed it, they wanted it, they worked at it, and they thought they were going to get better. And then they come to me a year later and say, I wasn't going to do anything. That's not my style. That's not what I do. But you know what? This has really changed my life, and I'm not getting better. Or I'm not where I was, and my doctors are telling me I'm not going to get back to where I was. And the unfortunate thing that I see many times is that happens with a lot of older folks. Our bodies are a little more frail as we get older, a little more susceptible to injury, and a little less likely to bounce back quickly. So, what does that mean in terms of limited tort versus full tort? Full tort is a misnomer. Full tort just means that you've retained all of your rights to do whatever you choose. That's all that means. All that means is you're not waiving anything. You're not giving anything up. You are retaining all of your own choices. That's what full tort means. What limited tort means is that you are saying that I am going to put in the hands of somebody else to determine whether or not I have the right to bring a lawsuit. Not me, but you. I'm putting it in the hands of somebody else. And ultimately, what that means is you're putting it in the hands of another insurance company to say, and to look at you and say, well, you know, I don't think that injury is serious. The fact that you can't play the piano the way you used to, and that's what you enjoyed, I don't think that's serious. The fact that you can't care for your grandchild the way you had been caring for your grandchild, I don't think that's serious. The fact that you can't lift a child anymore, or you can't reach overhead to get pots and pans, or the fact that you can't do your gardening, I don't think that's serious. You're putting it in the hands of somebody else. If you lose time from work, there's no doubt that that would be part of a claim. It's when you have ongoing pain and ongoing problems that the fact of whether or not you gave away your rights comes into play. So, what we want to look at is what do we see on our coverage, and can you put up number 4? And what does it mean to have full tort versus limited tort? Now, this is a minimal policy that doesn't require This only has the very bare minimum that is required by law. And what you'll see right on here, it says limited tort. And if you've selected that on your policy, those words need to be right on there. It means you've signed a waiver and the words are right on your policy. Yes?
Does that cost you money to have full tort?
There is a difference There absolutely does. The question you need to ask, and what you should ask your insurance company, is what is the difference? Most people have found that the difference, $20, $30, $40, maybe $120, maybe a month or a year. Sometimes some policies it's only maybe $200 a year difference. It can be very, very minimal. It depends on what your coverages are. Depends on the insurance company. Depends on if you have more than one policy with the insurance company. It depends on a lot of different factors. But many times it could be as much as $1,000 difference for some people, depending on what the coverages are. But when you look at the comparisons, it's something that you want to be educated about before you waive your rights. And I'm not suggesting that you can't make that choice. What I'm suggesting is that you want to make an educated choice. And you want to inquire and understand what's best for you as you grow older and as you reach different stages in your life as to what will or will not be a factor for you. Everybody is different. People make different choices, and the choice is fine. To have the choice is important, but you need to understand the choice that you're making. And it will cost more. There is no doubt. There's an incentive to not sell that, which is obvious, but there's also an incentive to have it to protect yourself. Because again, as I see, as people get older, we see more and more of the persistent problems. For instance, a back injury or a neck injury that really prevents you from doing things the way you have done them your whole life, or the way you had been doing them. Those kinds of injuries are often the ones that are succumb to that exact factor, where people, that succumb to limited tort, that people come in and say, well, I never thought that this would be a problem. This is serious to me. But it's not necessarily what's serious to you. It's serious as the law defines it. And so my purpose here is to explain that you have rights and you need to understand what they are. Yes?
Yes, I have a question. Would you recommend that somebody taking out an auto insurance policy, homeowners, see an attorney and let the attorney read through it? Or I don't think you could, in this day and this world, depend on your insurance agent because he's interested in selling a policy. Also, I have another question. If we had everything perfect, complete coverage and protection in our policies, what would you estimate it would cost percentage-wise over what we're paying? I mean, there must be some kind of a...
The insurance company is required to give you the comparison. If you ask for it, they are absolutely required to give you the comparative numbers. Most of the comparative numbers that I've seen are within a few $100s of each other. Very rarely is it outside of it for an annual policy. Very rarely is it outside of somewhere between $200 and $800 a year. Somewhere between. It really depends on the person and their driving history, having other policies. There's so many different factors, where they live, how many cars. There are a lot of different factors on what it is. Rarely is it outside that range, though. Rarely. And I would say if you have somebody, and I always make an offer to anybody, if you have a policy, you want me to look at it, contact me. I'll be happy to let you know what kind of coverage you have, just so you can understand it, to make the choice of whether that's what you want or whether you want to change it. My whole purpose is to education, to make sure everybody understands, because when I see people come in and they don't understand, that's the shame of it all, because the opportunity is there to understand. So yes, but if you contact your insurance agent, they are absolutely positively required to show you the comparison when you ask. They are required to. Let's talk about what is a serious injury, and what is limited tort, and what is full tort. Because again, these are words that lawyers use and words that insurance companies use, and not words that the average person uses on a daily basis. There are certain exceptions when you would, even if you selected limited tort, you would never be required or be held to that standard. If you were hit by a drunk driver, of course, assuming the drunk driver was convicted. If they were just written up or nothing ever happened, or they were drunk and everybody knew they were drunk and there was no prosecution of any sort, then it wouldn't be. But if you're hit by a drunk driver, by statute, you're not required, that limited tort does not apply. If you're hit by an out-of-state driver, again, then limited tort would not apply. There are a few other exceptions that sometimes, if you're a pedestrian, you're walking across the street, you get hit by a car, believe it or not, your own insurance covers you for that. I don't know, a lot of people didn't know that. If you're crossing the street and a car hits you, the coverages that you purchased here cover you. If that person didn't have insurance, your uninsured motorist coverage would cover you because you're a pedestrian, you bought that insurance. But you would not be limited tort. Motorcycles, which I'm not sure how many people here are riding motorcycles, but that's a different story. And an intentional act where somebody would cause an injury on purpose with a vehicle. That also is outside the realm.